can I register a trademark for a name even if I'm not using it yet? I'm going to answer that question today. I'm Angela Langlotz, trademark attorney, and I go live here on weekdays to talk about trademark and copyright law. Now, this is a question that I get all the time. Can I register a trademark even though I'm not using the trademark on goods or services yet? And the answer is absolutely yes. We have two ways to apply for a trademark. You can apply based on your use of the mark in commerce, or you can apply based on your intent to use the mark in commerce. And we say it's a bona fide intent. In other words, you are really intending at some point in the future to use this mark on goods or services that you are offering for sale, even if you haven't started doing it yet. Now, why might you want to do something like this? Well, you're probably aware that we are in an age of aggressive online copycatting, which means that sometimes when you put something out there and it has a cool name, some naughty copycat will go look at the trademark database, see that it's not registered or have an application in to register it, and then they will go apply to register it. That happens more often than you might think. Sometimes it's innocent, sometimes it's not so innocent, but it doesn't really matter the intent. If somebody else beats you to the punch and files their application first, then they are going to be in the catbird seat and you're going to have to prove that you were the first user if in fact you were using it. If you were only intending to use it, however, and they actually started use, then they have the better rights. So it's beneficial to you to actually register or apply to register rather the trademark that you desire when you first come up with the idea, if you're sure that that's the trademark that you want. Now, you may have some reasons for registering or applying to register before you've started actually selling the goods and services that are associated with that mark. It may be that you're still in the development phase for your product or service. You know the mark that you want to use, but it's not ready for prime time, so you're still developing it. You want to make sure that that mark is going to be available when actual use begins, so you file a trademark application based on your intent to use that mark in commerce. You may have a product that you're still developing, for example. That might be another situation. So you're continuing to develop the product. You've got the brand name, but engineering's being a little bit slow and they are still, making the prototype. You're still doing some testing and you want to make sure that the brand is available when you're ready. That's another scenario. You may, for example, also plan on a whole series of products using that name. Maybe you've got the first couple of products out, but the future products haven't been conceived yet, but you know that there will be future products. So maybe in order to hold the name and make sure that nobody else files something similar for similar goods, you may want to file intent to use applications for those products that are coming next in the series but haven't actually been produced yet. So we do this by filing a trademark application based on your intent to use. The general process of the application looks pretty much similar as for use marks that you're actually using in commerce, but the proof of use comes later. So it comes after the mark is published for opposition. Then you're issued what's called a notice of allowance. And that notice of allowance starts a 6-month clock ticking. And after that 6 month runs out, you have to, or before actually the 6 months runs out, you either have to prove your use or apply for an extension. Now you can ask for an extension for up to 3 years after the notice of allowance is issued. So once the notice of allowance is issued, you actually have 3 years that you can extend 6 months at a time. There's also a fee. They love to get us for fees. So you have to pay a fee and file an extension. And you can actually extend the time to prove your use up to 3 years after the notice of allowance. I'm Angela Langlotz. I'm a trademark and copyright attorney, and I go live here on weekdays to talk about trademark law. You can find me online at TrademarkDoctor.net, on Facebook at facebook.com/TrademarkDoctor, and I also have a YouTube channel where you can subscribe and be notified every time I go live. Like my Facebook page, you'll be notified every time I go live on Facebook, and I'll see you tomorrow.